Welcome to this Massachusetts Family Institute webinar with MFI and our general counsel tonight, Sam Whiting. We're just waiting for more people to come in to attend the event. So we're going to give it probably another minute or so just to give people time to come in. But we welcome you tonight. MFI does a lot of education work, especially in the education field. As you guys know, many concerning issues in our schools. I was at a church 2 weeks ago in New Bedford, and I had several public school employees come up to me and ask me questions about compelled speech, about Title IX issues, and so it inspired us to put on this webinar with our general counsel, Sam Whiting, to educate you all. Many of you, I assume, are either on a school board or you work for a school, or perhaps you're an activist in your local town or city or a parent. As mentioned, tonight's webinar is primarily for all of those people, but we are prioritizing answering questions and comments from school board members and school officials. And to that end, we do understand that school board officials and school officials can sometimes value their privacy on these kinds of efforts. And so when you want to ask a question, we ask that you put it in the Q&A. You click the Q&A button at the bottom, but there will be a button I think you can choose to make your question anonymous. If you don't make your question anonymous, then all attendees will see your name. And so if you want anonymity, please do take advantage of that, sending your question as anonymous. Please take advantage of that. And then also, if you'd like to give us some context, it would be helpful for us to know, if you are a school board member or school official, guidance counselor, teacher, if you'd like to, give some context in the question, feel free to, whatever your comfortability is, feel free to do that because you will be issuing your question anonymously. Okay, hope all that makes sense. So we have quite a number of people here attending now, and it's about 7:02, so I'm sure we'll get some more funneling in, but I will introduce now our general counsel, Sam Whiting. Many of you on the call, probably most of you, have been in touch with Sam regarding many of these issues, if it's not regarding Title IX or compelled speech, whether it's for students and or teachers, especially when it comes to pronouns and different names that are being used for teachers and students. What are your rights? That is one of the main questions we get. And so Attorney Whiting has about a 10 to 15 minute presentation he will provide, and as he's doing that, feel free to put your questions. Again, use that Q&A button, make your question anonymous if you'd like, and we will take those questions directly following Attorney Whiting's presentation. So Attorney Whiting, take it away.
Great, thanks so much. I am going to share my screen. So let me just do that real quick. Oh, can you enable screen sharing, Mike?
I can, I just did that. Yep.
Great. Go. Okay. You'll actually, sorry, I think I have it on the wrong screen. Here you go. Does that look good to you, Mike?
That looks great.
Okay, great. Well, thanks so much for joining us tonight. Yeah, this may go a little longer than 10 or 15 minutes. There's a lot of material in here to cover, but primarily we're going to be talking about Title IX, the new rules, what they are, what they do. We're also going to talk about, specifically geared towards school committee members, what your obligations are under the law. We'll also talk about how this relates to public school teachers, guidance counselors, and other employees. And hopefully this will be helpful. As Mike said, there's an opportunity for Q&A, so feel free to submit questions anytime during the presentation, and we'll get to those at the end. So first, I want to just talk about what is Title IX. As you all may know already, Title IX is a federal law enacted in 1972 as part of the Education Amendments of 1972. And it's federal law that was enacted with the intent to eliminate sex-based discrimination in education, both at the higher education level and also at the K through 12 level. So the basic provision, the fundamental provision of Title IX is what's on the screen here. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So if you look at that last part of this clause, this is a spending clause statute, which just means that basically this is strings attached to any school that receives federal funding, which in the United States is pretty much every public school. That's going to cover every public school. So any school that receives federal funding has to not discriminate on the basis of sex. This is a statute that's enforced by the Department of Education, which passes rules to kind of implement and fill out the details of what the statute actually requires. And so different presidential administrations will pass different rules to interpret Title IX. And so what we're talking about today is the new rules that the Biden-Harris administration has passed and their new interpretation, reinterpretation of Title IX and the effects that that has. So very broadly, what do the new rules change? A lot of the new rules have to do with due process protections. They've been criticized for weakening due process protections for students who are accused of sexual misconduct. There's a lot of changes in the new rules that we're not going to talk about tonight. School committee members, you'll probably want to familiarize yourself with those changes through your local school council, things like that. But what we're really concerned with tonight, and what MFI is especially concerned with because it intersects with our mission, is the fact that these rules redefine sex. So whereas the word sex in Title IX used to mean sex, biological sex, the sex that you were born with, now this new definition of sex means sex stereotypes, covers sex characteristics, pregnancy or related conditions. And then these last two are the ones that I think pose the biggest issues, which are sexual orientation and gender identity. So back in 1972, I don't think anyone foresaw that these rules were going to cover things like sexual orientation and gender identity. But now the Biden-Harris administration is saying that they do. So let's talk about the consequences of redefining that word sex. In the law, redefining one word can make a huge impact. And that's what we see with these Title IX rules. So there's really four major areas that we're concerned about here with this redefinition of sex, because when you say that now, sex discrimination includes discrimination on the basis of gender identity and sexual orientation, you're going to get into problems with girls' privacy, freedom of speech, fairness, and safety in sports, especially girls. Breakingly, girls' privacy, obviously, we're talking here about bathrooms, locker rooms, showers, also overnight accommodations on trips, things like that. What these new rules explicitly state is that every school in the country now is going to have to open up their bathrooms, locker rooms, showers to biological males who identify as female. The rules also suggest that it could be sex-based harassment to not use the preferred pronouns of a student or a teacher in a school. So if you have a student who's biologically male, but he wants to be called she, her, you have to use those pronouns. And if you intentionally don't use those pronouns and you use he, him instead, then that could be sex-based harassment. And you could be, if you're a student, you could be subject to an investigation and discipline. If you're a teacher, you could be fired for that. Fairness and safety in sports. Although the Department of Education has tried to say that these rules won't impact sports, it's our belief that they will, at least in the long term. The Department of Education guidelines say, oh, no, we're not intending to change anything about sports. You don't have to worry about that. I think they say that because they know that it's a really unpopular stance to take. Most people understand that, girls should have separate sports from boys. But if you redefine sex discrimination to include discrimination on the basis of your identity, I don't think there's any way around the fact that in the next few years, you're going to see schools being forced to allow biological males play on female sports teams if these rules stay in place. And then the last bullet point here, parental rights. Specifically, what we're talking about here is situations that you may have heard of that are really horrifying, where schools are intentionally concealing information about a student's gender identity from that student's parents. Under these rules, we believe that this could be interpreted to require schools to conceal that information because otherwise they could be engaging in sex-based discrimination against a student who identifies as transgender. We've already seen this. We've already seen schools do this in a number of municipalities in Massachusetts and across the country. One school district in Ludlow, we're actually engaged in a lawsuit against them. We have been for a couple of years now. It's on appeal. But these are rules that are intentionally withholding information from parents, using one set of names and pronouns for a child at school and a different set of names and pronouns when they communicate with the parent so that the parent won't find out that the child is identifying as transgender. And then they're actually disciplining teachers if they reveal this information to parents. So a really, really problematic situation in a lot of schools across Massachusetts and across the country. Now, if you know anything about Massachusetts law, you might have the question, what difference does this actually make in Massachusetts? Because in Massachusetts, we already have a lot of really bad laws on the books and a lot of laws that actually already require Massachusetts schools to do many of the things that these new Title IX rules would potentially require them to do. So, for example, in Massachusetts, we have a Supreme Court ruling and we have regulations from DESE, the Department of Elementary and Secondary Education, that say that you have to allow trans identifying male students onto female sports teams. And in fact, the Supreme Court case says you have to allow not trans identifying male students onto female sports teams if there's no equivalent male team, which is how you get incidents like we saw in Dighton Rehoboth, where a female field hockey player got her teeth smashed out by a male player because there was no equivalent male field hockey team. And so males can play on field hockey teams in Massachusetts. So, the sports issue, the new Title IX regulations probably don't make much of a difference in Massachusetts. Also, the bathroom and locker room issue, it's kind of, there's not super clear guidance on or super clear language in the law on whether schools have to open their bathrooms up to the opposite sex, on the basis of gender identity. Probably in Massachusetts, unfortunately, a court would rule that way. So it's not likely, the rules that require that now probably are not likely to have a huge impact in Massachusetts either. But the two areas that we're especially concerned about that are pretty clear problems with these new Title IX rules are the areas of free speech and parental rights. So again, free speech is an issue because this is now going to compel teachers, guidance counselors, potentially even students to use preferred names and pronouns for other students or school employees. And so that's a really big free speech and religious liberty concern, since people of a lot of different religions have religious objections to that as well. The reason that comes up as a specific issue in Massachusetts is because although there's DESE guidance saying that teachers should use pronouns for students, there's no law that clearly requires schools to use certain pronouns, preferred pronouns for students. So we think that these new Title IX regulations are just going to allow school administrators who want to enforce pronoun usage to point to that and say, hey, this is federal law. Our hands are tied. You have to use the pronouns that a kid asks you to use. And if you don't, then we'll fire you. The other area, again, is parental rights. And so again, in Massachusetts, we've already seen schools withholding information from parents, but we think that these Title IX regulations will give them even more of a justification to do so. In the Ludlow case that we litigated, even though the case was dismissed at the district court level, there was a really important line from the district court that said that the Ludlow school's policy of concealing student gender identity actually conflicted with the DESE guidance, which says that you're supposed to talk with the student before you talk to their parents, but it anticipates that you are going to reveal to their parents that the student is experiencing a gender identity issue at school. So the court basically came out and said, you're not even following DESE guidance here, but they still ruled in favor of the school on kind of a technicality. So it's pretty clear in Massachusetts, if you look at that decision, that schools are not required by Massachusetts law, teachers are not required by Massachusetts law to conceal information about a student's gender identity from their parents. But these new Title IX regulations, again, will kind of give more ammunition to schools that want to do that to say, well, actually, we are required to do this, maybe not by Massachusetts law, but now by federal law, which preempts any other, Massachusetts law. So that's why we think these two specific areas are kind of the most problematic for schools in Massachusetts. So the big question that people are asking us now, and I think this is very timely, is are Massachusetts schools required to actually implement these new rules? Because you might have heard in the news that courts in a number of different states have issued injunctions against these rules. An injunction is basically just a temporary order saying that you can't enforce this for the time being until this kind of gets played out in the court. We decide whether this is actually legal. So Massachusetts does not have one of those statewide injunctions. There are 26 states that do, I think, by my most recent count. Massachusetts does not have a statewide injunction. So it's not all Massachusetts schools are exempt technically from enforcing these new rules. However, and I think this is a really important point, there is an injunction that applies to certain Massachusetts schools. So it depends on what school you're at, and that injunction applies is a federal court in Kansas. They handed down the injunction, but it applies to all schools that have students who are children of Moms for Liberty members, or students who are members of the groups Female Athletes United or the group Young America's Foundation. So again, just to make it clear, if you are a Moms for Liberty member and you have a student in a Massachusetts school, that school is covered by this injunction. And what that means is that that school, they could still implement the Title IX rules. They could still pass a policy, adopting those rules, but they're not required to do that. The federal Department of Education cannot come in and strip away their federal funding or implement any other kind of disciplinary action against them because they've implemented these rules. So I think that's really important for people to know. We are encouraging as many people as possible to sign up for Moms for Liberty or enroll in these other groups. I'll get to the next slide here, which is our text short code. So if you text the word mom to 87891, that's MFI's short code, you'll get information on how to sign up for Moms for Liberty. And by doing that, you can get added to the list of schools that are covered by this injunction. So we've drafted a brief on all of this information regarding Title IX, which we'll distribute to you either during or after this session. But if you text this short code, you can sign up for Moms for Liberty. There is a list of every school that's covered by this injunction so far, but you actually don't have to be on the list to be covered by the injunction. You just have to tell the school that you're a member of Moms for Liberty and be covered by injunction. I think it's also important to note this applies to specific schools and not whole districts. So if a school in your district is covered, that doesn't necessarily mean that your school is going to be covered. You have to have a child, that's covered at your school. So again, sign up for Moms for Liberty, text this short code, go to their website. We'll also send out our brief with more information about that. But I think this is a really important point to emphasize for any parents in the audience. Now, this is another question that's come up from school committee members, which is even if our school is, does technically have to enforce these rules, it does have to implement them, and we're not covered by one of the injunctions, what's the risk if we just choose not to implement them for now? And I think the bottom line answer here, I'm not going to give specific legal advice, but you can reach out to me if you want to talk more. But the bottom line answer is that the risk is likely minimal at this time. Considering the ongoing litigation, considering how things are in flux, I can't make any guarantees that there wouldn't be action taken against your school. But I think it's also just important to emphasize that in the 52 years that Title IX's been in effect, no school has actually ever lost federal funding for noncompliance. Plenty of schools have been found to be out of compliance, but there are certain intermediate steps that the Department of Education will almost always take before they take that drastic step of taking funding away, because they don't want to, strip funding away from a school, which would harm the kids that go to that school. So usually, if you do something that violates Title IX, you're going to have a pretty lengthy investigation. It could go for months or even years, and then there's going to be some kind of chance to take a remedial action. So what we would anticipate in this situation is if you don't implement the rules and the Department of Education actually takes action against you, you would have a chance to voluntarily implement the rules before, certainly before your federal funding is taken away. So that's why I think a number of schools, even schools that are not covered by one of these injunctions, are kind of taking a wait and see approach. That wait and see approach. I think there's a number of pretty compelling reasons. One, of course, is that there is ongoing litigation. It's not clear right now whether this rule is actually going to be upheld as legal. There's a number of reasons that it could be illegal, both because it affects things like First Amendment rights, but also just because it probably goes beyond the plain language of the statute. Again, I mean, in 1972, I don't think anybody thought that sex was going to mean gender identity or sexual orientation. So there are big questions as to whether this is actually going to be legal. So if you don't have to implement the rule now, and you're not inclined to do that, I think you can look at the ongoing litigation and say, if we don't have to implement this now, why should we? I think another maybe even more compelling point is that there is potential liability for implementing this rule. So what you'll hear, kind of on the other side of this argument is, well, if we don't implement this, then we're going to get sued. We're going to get sued by the Department of Education, or we're going to get sued by a student for not, upholding their Title IX rights. You got to think about the liability potential on the other side of that equation, which is if we do implement these regulations, what about students whose First Amendment rights are violated? What about parents whose parental rights are violated if we don't tell them that their student is struggling with a gender identity issue at school? What about female athletes or girls who have a right to privacy in the locker room or the bathroom? What about their equal protection rights? So I think the liability factor here is a real reason to kind of pause and say, wait a second, do we want to implement something before we know whether it's legal and before we know whether we're going to be on the hook for all of these liability issues? And then I think the last point is just kind of the basic fairness point. Is this something that's actually good, especially for girls in our school? And again, if we don't have to implement it yet, why should we? So I think there are strong reasons to take a wait and see approach. Again, I think every district's different, and I can't give specific legal advice for your district. But if you'd like to talk more about issues in your district, we're certainly more than willing to do that. I did just want to briefly touch on some policies that I think can prevent some of the negative impacts from these new rules. So even if these rules are implemented in your district, I think there's still policies that you can pass to kind of blunt the impact of some of these rules. So the first one I want to talk about is the sports opt-out policy, which is a policy that's been passed at least in one district in Dighton Rehoboth, but I think other districts in Massachusetts are strongly considering it, maybe even already in the process of passing it. And what this policy does, it's very simple, very non-controversial, I think, in my opinion, which is that it allows coaches and athletes to choose to sit out games, forfeit games where they're going up against teams with athletes of the opposite sex. So if you're a girl and you're playing sports and you're concerned about your safety or your fairness, and you don't want to play in that game, you won't be penalized by your school if you choose to sit out. Or if you're a coach who doesn't want to subject your athletes to those risks, you can sit out and the school committee will stand behind you in that decision. So very simple policy, very simple amendment to the existing sports policies that most schools already have on the books. If that's something that you're interested in, reach out to us. And again, we'd be more than happy to discuss that. Two other things, just free speech protections. I think you could pretty easily add into your policy manual, even add into the sexual harassment, sexual discrimination policy to say, nothing in these policies is intended to force students or teachers to use preferred pronouns that conflict with their religious or philosophical beliefs. If a student or a teacher is really harassing another student for being transgender, then that would fall under the school's bullying policy. So it's really not necessary to incorporate this, pronoun compelled speech rule into your sex discrimination policy. And I think there's an easy way to just kind of clarify that, look, we're not going to violate anybody's First Amendment rights here to believe what they believe and not be forced to speak a message that they don't believe. And finally, a parental transparency piece. I think you could pass a policy that basically says the school's not going to withhold any information from parents regarding important issues about their students' mental health, and they're not going to punish teachers who choose to disclose information. Again, pretty simple policy, but it would really help with some of these situations where parents' rights are being violated. I could go into those in certainly more detail, but I think it's probably most helpful if people just reach out to us and we can speak with people one-on-one about the situations in their specific districts. So that's a broad overview of Title IX policies that you can implement to kind of help with the effects of Title IX with the new Title IX rules if those are passed in your district. I did want to talk about this kind of intersecting area of compelled speech for public school teachers, which is an issue that comes up a lot for us at MFI. So, as I've talked about already, not just Title IX, but a lot of school districts, kind of at the suggestion of DESE, are requiring teachers, guidance counselors, pretty much any employee, to use preferred names and pronouns for students who identify as transgender. Obviously, for a lot of teachers, especially teachers of faith, this poses a massive issue, massive free speech issue, and a massive religious liberty issue. And so there are legal protections, especially for teachers in public school. This is an issue that's being litigated, and it's very much ongoing. There's cases all across the country about this because there's just a fundamental clash between, especially, the religious, especially Christian, Judeo-Christian worldview and this LGBT ideology. So teachers do have legal rights that they can stand on here, both rights to free speech and religious liberty, and also rights to religious accommodation under state and federal law. There's the federal law, Title VII, and then there's also state law, Massachusetts General Laws, Chapter 151B, which provides employment discrimination protections. And so if you're facing a situation where you're being compelled to use names or pronouns that violate your philosophical or religious beliefs, we definitely want to hear from you because we can help you draft letters to your administration asking for that religious accommodation, explaining your free speech and freedom of religion rights. Again, this is very much an ongoing issue, and Massachusetts courts probably are not necessarily going to be the most friendly to our perspective on this, but this is an issue that eventually is going to go to the Supreme Court and will have to be litigated at the highest level. So there are steps that you can take to protect your conscience now. And we're always looking for people who are kind of brave enough to step up, speak out, and actually take a stand for what they believe. Because unfortunately, a lot of these situations, people reach out to us and they want help, but they're not always willing to kind of take the risk of litigating these issues. And I get that. It's not my job on the line. It's not my livelihood. But I think we do need courageous people to stand up against this ideology. I wanted to just briefly, I won't belabor this at all, but briefly touch on a couple of the encouraging developments in compelled speech case law. The kind of foundational case for compelled speech jurisprudence is a Supreme Court case from, I think it's 1948, called West Virginia Board of Education versus Barnett. And that was a case where some Jehovah's Witnesses did not want to pledge allegiance to the flag in school. And the Supreme Court held that they had the right to do that under the First Amendment. And there's this great quote from Justice Jackson. I'll just read it out loud now, where he says, "If there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein." So essentially, the government can't tell you what to believe, and it can't force you to state something that you don't believe. It can't force you to conform to orthodoxy of the day. And certainly in public schools, the orthodoxy of our day is gender ideology. So we've seen some encouraging developments in some more conservative areas, but I think developments that are likely to have an impact even in places like Massachusetts. One of those cases is called Merriweather versus Hartop. That was a case out of Ohio in the Sixth Circuit Federal Court of Appeals, where a professor had a student in his class who identified as transgender, and he proposed an accommodation. He was a Christian, so he felt like he couldn't call this person by pronouns that invalidated, their God-given biological sex. So he asked for an accommodation where he could just use the student's name and not have to use pronouns. But the school rejected that and said that that would stigmatize the student, and they disciplined him for failing to follow their policy. So this professor sued, and fortunately, the Sixth Circuit found in his favor, especially on academic freedom grounds, saying that this professor he was actually a philosophy professor. He's speaking about all of these subjects, and he's speaking about his opinions about these subjects. And the classroom is supposed to be a marketplace of ideas and a place where people can share different opinions on things. And so by forcing him to adopt an opinion that he doesn't actually believe in, you're violating his freedom of speech, and you're violating his freedom to teach as he wants to as a professor. So that was in the higher education context. It's kind of unclear whether, like, to what extent that applies in K through 12. But there was another great case, really, really good case from Virginia recently, in the Virginia Supreme Court. So a state court case. This one was called Vlaming versus West Point. And in that case, the Virginia Supreme Court held that their free speech and freedom of religion clauses basically absolutely barred schools from requiring teachers to use preferred names pronouns. A similar situation where a Christian teacher was actually fired after requesting an accommodation to just use names and not pronouns. And the Virginia Supreme Court issued a really strong opinion that we hope that other courts will follow. I think the Massachusetts courts would not necessarily go as far as the Virginia Supreme Court did, but I think it's really persuasive authority, and just a great I think beacon of hope for people in all different jurisdictions that courts still value the freedom of speech and freedom of religion. And then I just finally wanted to touch on parental rights against gender deception, and also talk about teacher rights to not participate in gender deception. But under the 14th Amendment to the US Constitution, and also similar clauses in the Massachusetts Constitution, parents do have a constitutional right to the care, custody, and control of their own children. And so what that means is that the state can't come in and interfere with your decisions to parent your own children unless they find that you're unfit to parent because for reasons of abuse or neglect or something like that. But if you're a fit parent, you have the right to make decisions for your children, and you can't make good decisions for your children if your school is actively deceiving you about something that's fundamental to their mental health. So again, this is an issue that is still very much being litigated. It's still kind of up in the air as to what direction the courts are going to go with this. But there have been some encouraging developments again in some other courts in other parts of the country where they have held that parental rights were violated when schools adopted policies of deception. I think it's really revealing that most schools that are doing this don't actually have a written policy on it because they're afraid that if they have a written policy, then they'll get sued. So they're hiding their policy and they're just kind of doing trainings for teachers and things where they tell teachers you can't out students to their parents. That's how they see it. But they won't actually adopt policies that say that. So this is happening in many Massachusetts schools, unfortunately. And if you're a parent whose student is being secretly socially transitioned and you found out about that, or if you're a teacher who's being forced to participate in this kind of deception, we definitely want to hear from you. There are things that we can do to help. I think especially for the teacher or counselor context, if you're being forced to go along with this in violation of your religious beliefs or otherwise violate your free speech rights, things like that. I really think that that could be one of the best possible avenues to chip away at this LGBT ideology because it's just so blatantly wrong what they're doing. And I think people could have a really good claim against this stuff. So that's a broad overview of Title IX, what the regulations are going to do, whether you have to implement them, and then also just some specific issues with compelled speech and religious liberty for professionals in the public school setting. I think there's plenty more that we could talk about, so we certainly welcome questions. As I said, either in the chat here or afterward in an email, we'll certainly send out a link to the brief that we recently did on Title IX, and hopefully that will prove useful for some people. But Mike, at this time, I'll turn it over to you, and I think we can probably do questions.
Great, thanks, Sam. That was really great. We have about 10 questions here that we'll just go through, and if you could answer them to the best of your ability, that'd be great. It says, "Good evening. I'm a school committee member, and my question is in regard to PPRA and a public school teacher's right to simply ask students their preferred pronouns in an informal questionnaire. Parents were not notified of the questions."
Yeah, this is a question that we've gotten before. So just as way of background for people who might not know, the PPRA, the Protection of People Rights Amendment, is essentially it's a federal funding statute like Title IX. Every school that gets federal funding has to comply with it. And what it says is that if schools give students surveys that they have to take regarding certain specific kind of sensitive information, like their mental health, like whether their family has family issues, whether they do drugs, whether they're sexually active. If schools administer invasive surveys like that, then they need to provide parents notice and a right to opt their child out of those surveys. So there's a question, right, as to whether handing out a form in class or even informally, verbally asking students about their pronouns would fall under the PPRA. From our perspective, we think it does. We think that the term survey is actually not defined in the statute, but it uses language like survey, assessments, evaluations. So it's supposed to be broad, and it never says that it has to be a written survey or anything like that. So we believe that these types of informal in-class surveys would be covered. We think that pronouns would fall under sex behaviors and attitudes or maybe mental health issues of a student, since pronouns are typically connected to students who are experiencing gender dysphoria. We don't know what perspective the current administration's Department of Education would take on this. We don't. My guess is that they probably would kind of drag their feet on even getting to enforcing this. But I think it's at least a valuable tool to use to at least threaten and say, hey, we think you're violating the PRA if you're doing these surveys, and we are, we're going to file a complaint if you don't stop doing this. I'll also just, lastly, I'll say that this question was from a school committee member. I think, as a school committee member, if you can get other people on board on your school committee, you have an absolute right to pass a policy that touches on this and clarifies that surveys include things like asking students about their gender identity. Or you could just pass a policy that says, no student shall be asked about their about sensitive information, including their gender identity or their pronouns. So if you're interested in something like that, definitely feel free to reach out to us. Contact or info@mafamily.org.
Yeah, I just want to add to that too, Sam, that you can text the word education to our short code 87891. Again, text the word education to 87891, and you can get a link not only to the opt-out form for sex ed that we believe is inappropriate and not medically accurate, but you can also get an opt-out form for the surveys. So definitely take advantage of that. Text the word education to 87891. Same, I believe, is the same attendee. Not a question, but just wanted to say, forgot to include that I am a member of Moms for Liberty, and the school has received all documentation regarding the current exemption to the new Title IX changes because of my membership to Moms for Liberty. So it's great to see here a school board member, providing that information for Moms for Liberty to the school, taking that
Yeah,
action step.
it's fantastic.
All right, next question. Just putting in my 4 questions early. Here you go, Sam. If a school is on the Moms for Liberty list, can school committee administration still decide to implement the final rule to students who aren't on the list? I am on a school committee for context, and superintendent thought this.
Yeah. So yes, my understanding is yes, you can still implement a policy that tracks with the new rule. What the injunction is not against specific schools. The injunction is against the Department of Education from enforcing the rule against that specific school. So your school can still decide to do whatever it wants, but the Department of Education can't force you to implement the new rules. So, obviously, if you're covered by the injunction, our recommendation would be don't implement the new rules because they do a bunch of these new terrible things. Um, but yes, technically, you still could implement the new rules through adopting the policy that tracks with them.
Next question. Also, my town isn't listed on the court document yet, but I know that some parents have become Moms for Liberty members. Would school be exempt?
Yes, if the administration and the school committee is made aware of that. So the way that the injunction is written is it applies to any school attended by children of Moms for Liberty members. The list is really just for notice purposes, but if parents notify the school themselves while they're waiting to be put on the list, that should count for the purposes of the injunction. Now, if the parents don't notify the school, then the school's not going to know and they don't have to comply with the injunction. If your school's not on the list, but you are a Moms for Liberty member, reach out to the school and tell them that.
Yeah, would you also recommend that they maybe do a printout of, go on to Moms for Liberty site or something and show that you filled out the membership form?
Yeah, if they ask for verification, I would do that.
Question number 3, does it cover all schools in the district or only the school that has a child of a member of Moms for Liberty?
Yeah, so it's the latter. It's only the school that has the child of Moms for Liberty, which is why we're encouraging as many people as possible to sign up, because it is school specific. It does not cover the whole school district.
Regarding new definition, what are the differences between the way the laws in Massachusetts protect gender identity and Title IX? Don't we already have to abide by this?
Yeah, so I think we hopefully we covered that earlier. I think these questions were put in at the beginning, but basically I think that the two main areas that we're especially concerned about are free speech, the compelled pronoun usage, and then also parental rights and deceiving parents about gender identity. I think there's also, somewhat of a question as to whether Massachusetts law will go as far regarding bathrooms and locker rooms. And kind of a tangential, not, I guess not tangential, but kind of a subset question of whether Massachusetts law would require students to share sleeping arrangements with members of the opposite sex. So those are things that are a little bit up in the air. But again, the main issues I think are free speech and parental rights.
Okay. Great. Moving to the next attendee. Our school committee is going to be addressing Title IX rewrites as an agenda item on September 23rd and have told the public to submit questions in advance. What questions should we be asking our school committee about Title IX rewrites?
Yeah, that's a good question. I think I would use our brief that we're gonna send out, and I would say, is it true that this is going to redefine sex to include gender identity, and is it true that this is going to force us to violate the free speech rights of students, free speech rights of teachers by forcing them to use pronouns and names? Is this going to make it more likely that the school is withholding information from parents regarding their students' gender identity? Is this going to open up the school to liability? Is this going to require students to share sleeping accommodations? Basically, all the things that we just talked about. Bring up those questions and make the school committee answer them on the record. Because I think that, the more informed that you are about this and the more that you can kind of put them on the hot seat, the easier it'll be to potentially, if you have friendly school committee members, drive them toward tabling it or just killing it for the time being.
Next question. It sounds like many teachers are trying to avoid using pronouns altogether and just using students' names. How does this relate to any issue of compelled speech or free speech if you just avoid pronoun use?
Yeah, so that is the typical that like that's what I would recommend most teachers is, if you're in a position where your conscience would allow you to use a child's name but not their pronouns, just don't use pronouns for that student. And the way that I think intersects with free speech is that for most public schools, um, they are not going to see that as good enough. They're going to say that, if this student notices that you're not using pronouns for them, then they're going to feel discriminated against. And so they're going to try to force you to actually actively use that student's pronouns and say something that you don't believe. So if you can fly under the radar that and just not use pronouns for a student, that's always my first recommendation. Don't make an issue out of it until it becomes an issue. But when it becomes an issue, reach out to us and we can submit a religious accommodation request for you, which is kind of the first step in protecting you. Um, Both because if they grant the request, then that's great, you're golden. But if they don't, then that sets you up for a lawsuit in the future if unfortunately they do end up taking some kind of disciplinary action against you.
What if they don't want to use the name that they're given?
Yeah, so that's a tricky, I mean, that's a harder situation. And, you know, I'm kind of personally, I'm torn about, should we use names or not? Some people, their perspective is, well, a name doesn't necessarily communicate anything about gender. Anybody can change their name. But others, if the person's named Chris and then you have to call them Cindy, that feels pretty wrong for a lot of people who don't believe in this gender ideology. So, I mean, in that situation, first of all, um, I would just try to avoid interaction with that student if you can. But if you can't avoid interaction with the student, yeah, I think the next best thing is to request an accommodation to use last names, something along those lines. We can help you craft that, but that's a tougher situation. We still, our position is that you should be able to get that accommodation. I mean, you should be able to use the biological pronouns if we're being honest about this. You should be able to speak truth. But I think the next best thing is to just request an accommodation to use a last name if you can.
Next question. You said schools are not required to conceal gender identity from child's parents. Where can I get legal info for my school's attorney and superintendent who are saying otherwise?
Um, have we written a letter on this? I feel like I have written an advisory letter potentially on this before. So definitely reach out to us. I don't think we have anything published necessarily on this. But the case that I would definitely point you to is that Ludlow case. So it's Foot versus Town of Ludlow, school committee, 2022 case. And the judge in that case clearly stated that this is not required by DESI guidance, and in fact contradicts DESI guidance. So your, your school's attorney and your superintendent are either um, ignorant or willfully ignorant and misleading you on this. And we've seen that from a number of different school districts where they try to hide behind the law, but the law really doesn't say what they're saying it does.
Yeah, if you're looking up the Foot v. Ludlow case, it's Foot spelled Foote. So how you regularly spell foot, but with an E at the end. Next question. If one signs up for Moms for Liberty, do you have to have a student in the school to have standing? I think we already answered that.
Yes, you do.
Next question. Can you provide us with sample policy changes proposals to suggest to our school committee for the 3 areas you say can prevent negative impact?
Yes, we can. Reach out to us. We have not published those publicly. We're kind of in the process thinking about creating a public model policy page for people to just draw from. But I think it's helpful to have direct contact just because we can kind of tailor things for what you need. So reach out to us and happy to set up a call with you. I will just say to school committee members uh, who might be on this call who want advice, reach out to me individually. That'll just help you with privacy issues, things like that. And we can definitely have a conversation about this. And my email address, I'll put this in the chat now for people, but my email address is sam@mafamily.org. So I'm going to put that in now.
Okay, great. How do teachers' free speech rights relate to the new Title IX potential sex discrimination for not using names, pronouns? I think someone already answered that.
Okay.
Parental rights against gender deception. Is there an age limit on this?
As in, yeah, I mean, so at 18, your child's no longer a minor. Then they do have the right typically to determine what information gets shared with parents. So under state, under like FERPA, which is a federal law governing, whether records can be shared with parents, that's going to be, they're typically going to not have to share that information with you. There might be a little bit of a gray area there if they're still in school and you're still responsible for them, but typically once they're 18, they're legally an adult. They are going to be able to talk with the student about what gets shared with you and what doesn't.
So this is a statement, interesting statement. I wasn't aware of this. I don't know if you were or not, Sam. Our district has a written policy and gender support plans that reflect the policy. There was also a local news article about our policy where the school committee chair says teachers and staff can act as, quote, transition support and not involve parents. So this is
Yeah.
all out in the open.
Yeah. 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 And so they're getting more blatant about this. I think it's foolish because it makes for great evidence. There's still some question as to whether a parent would have standing in a situation like that, just because you'd kind of have to show that your child would potentially be subject to that, would be harmed by that. So, it's a interesting question as to whether even if your child was not being secretly transitioned, whether you could still sue the school for even having a policy like that on the books. Again, still kind of currently being litigated, but certainly if there's a child in that school who is being secretly transitioned and the parents find out, I think they would have a really good case that this is the school's official policy. I'll just I won't go too far down this rabbit hole, but in the Ludlow case, one of the reasons that our case was dismissed was because there was no written policy, and the court said basically this wasn't an action taken by the school committee, it was just an action taken by some administrators. And to show that this type of executive action is unconstitutional, it has to meet this really high standard. But if it was a written policy, it would have had to meet a lower standard. So I think in a situation where you have a written policy and you have a violation of a specific parent's rights with regard to a student who's being secretly transitioned, you have a really good case.
So, Sam, just to kind of further go down this rabbit hole, at this particular school, do you have to show harm in order to bring a case now that there's a policy? Or can you just bring a case based on the policy?
Yeah, so that's what I was kind of getting at is, it's the jury's kind of out on that. I trying to kind of reach back into the recesses of things I've read. I think there have been cases where parents have challenged policies like this and they've lost because courts have said you can't show that your kid specifically was harmed by this, and so you don't have standing. But there might be case law on the other side of that equation. So it's not clear to me exactly how that would play out in Massachusetts, but it's definitely something that I'd be willing to look more into.
So all I have to say is, whoever wrote that comment, definitely get in touch with Attorney Whiting through the email he put in the chat, because that would be, especially if you find harm. I mean, if you find that a child has been transitioned, I mean, it seems like a no-brainer then to bring a case at that particular
Yeah,
school. So great comment.
that's right.
In the topic of parental rights against deception, have there been parent groups who have proactively contacted schools standing up against schools hiding such crucial info from parents regardless of what the student wants?
I imagine there have, certainly in across the country, and there's some great parent groups here in Massachusetts that are kind of putting the administration on notice of things like this. One of the problems is the case law in Massachusetts with the Ludlow case. Schools will often point to that and say, "Hey, this gives us the right to do this," and of course that's not true. It kind of says the opposite. But I think there's certainly value in at least putting schools on notice that you're watching them, that you're paying attention to what their policies are, and that you'll hold them accountable if they do violate parental rights. And so, an ounce of prevention sometimes is worth a pound of cure. So that can be helpful.
I just put my email in the chat as well, just because that particular question made me think that there's over 40 parent alliances that we are aware of that we are working to help organize, and we offer all kinds of services, whether it's legal support, policy development, with these parent alliances, helping you network within your town or city to be effective. Like we just said, maybe finding a plaintiff, that didn't know that they had the right to, or even that a case could be successful to push back. So, like I said, there's about over 40 of these parent alliances that we're aware of. And if you want to be a part of this bigger group, there is a meeting coming up at the end of September that I'd be happy to give you more information about, where you will meet a lot of like-minded parents that have organized in this way, and school committee members and the like. So definitely email me if you'd like more information on that. Michael at mafamily.org. Um, okay, next question. I'm a school committee member. Is there a legal definition of gender fluid?
I don't believe I've ever seen one. And the definitions even of gender identity that I've seen in our state law are circular. Like they say that, gender identity means the gender that someone identifies as, the feeling of gender that they, choose for themselves or something like that. Very, very vague, really kind of a non-definition. So a lot of these things don't they don't have clear definitions. And that's something that you can definitely push back on if people are using that language, is like, can you define that for me? What does that actually mean? Can you define it in a way that you're not using the same word to define the word that you're trying to define?
And then just the last question is, will this be recorded? Yes. And we can definitely send that out to all of the people that registered for tonight's webinar. Those are all the questions that we had listed here. We did want to go to about 8 o'clock, which it is. So just some final comments. Sam, was there going to be some kind of brief or handbook that we wrote on these issues that we are sending out to people that we can make them aware of?
So I just dropped the brief in the chat so everybody can see that. I think we will also send that out via email, just blind copy, people, so that this stays anonymous. But we have the brief on the Title IX issue. At some point, I think we're going to develop a brief on these compelled speech issues that people will have. Again, if you're interested in model policies, especially if you're a school committee member, email me specifically. Email me and don't CC other members of the MFI team if you want to talk, policy specific to your school committee, just because that'll protect your privacy rights as a school committee member, to make sure that we can have conversations that are confidential and as open with each other as possible. So just email me at sam@mafamily.org. But yeah, hopefully that brief will be helpful to school committee members and any activist or other community member who wants to be informed about these Title IX changes and make the best decisions for their schools as they can.
Yeah, and just to kind of wrap up some other things, just we talked about, some action items tonight. Text mom to 87891 to get information on how to sign up for Moms for Liberty, and then other information about the injunction. MFI is here to not only network and build alliances like we talked about, but also on the school board level to pass policy. Just want to reiterate, Dighton Rehoboth passed a wonderful safety and women's sports policy that went viral after they followed through with the policy this fall. And not only the coach, but the captains of the field hockey team decided to forfeit a game. And Riley Gaines came out and said, yeah, I definitely support this policy. She actually said that she never should have gotten in the pool. She should have forfeited that race against Thomas. So she actually loves the policy. And then also we do training. You want to run for school board? Yes, we do training on that. You can text the word school to 87891. Text the word school to 87891 to get more information on upcoming trainings. And that's about all I had on that. Do you have any other comments, Attorney White?
So I just look forward to hearing from people if I want and follow up on any of these issues. And hopefully this was helpful.
Yeah, it looks from the questions, it was very helpful. Real quick, I just got 2 last minute questions here. Any parent alliances in New Bedford? I have to look into that, so email me and I will put you in touch with who is organizing that effort. But please do take advantage of that. The more we can get networked and organized, the better. So please email me, michael@mafamily.org. Yes, a brief on the compelled speech issues would be very helpful. I've been publishing your briefs on social media to the community. Thank you so much. Thank you very much. Copied the DR policy I've submitted to my. Okay, great. So school committee members working together, town to town, copying successful policies. So that's really great. Yeah, we want to do more and more of that. So if you're a school board member, like Sam said, email him and let's get some common sense policies passed at the school board level. All right. Well, thank you guys so much for taking time out of your Thursday night. Hope this was helpful for you. I'm sure we'll do more stuff like this. Pay attention to our e-alerts, our text alerts for more helpful events like this. We hope you have a great night, and we will see you soon. As we always say, you are not alone here in Massachusetts.
Thanks, everybody.